Jai Hind. Do democracy and justice exist in India? Or is it just a mirage? Have you ever wondered whether democracy and justice exist in India? If yes, in this video I'm attempting to answer the same question with the help of undeniable facts. And before examining whether democracy and justice exist in India, it is important to understand what these terms mean and the context with which I'm using them here. Democracy may have many definitions, but when I use the term democracy, I mean the same democracy as in the definition of Abraham Lincoln. These are his words in quotes. Democracy is the government of the people, for the people, and by the people. And when I use the word justice, I mean the fair and impartial treatment of all individuals in a society. Justice involves upholding moral, legal, and ethical standards in the distribution of rights, benefits, and opportunities, as well as in the administration of punishment for wrongdoing. Justice requires that all individuals be treated equitably and without prejudice or discrimination based on factors such as caste, race, gender, language, religion, or socio-economic status. It is the cornerstone of a democratic and fair civil society and is essential for the protection of human rights and the promotion of social, economic, and political equality among the citizens. Now let us analyze whether justice in India is a right or a privilege. We will also see how the answer to that directly determines India being a democracy. Justice delayed is justice denied. Here in India, justice is always delayed. The length of the litigation is a nightmare to any litigant. The citizens are afraid of the length of the court proceedings to the extent where they think it is better that they accept and adjust any injustice that happens to them, rather than further wasting their valuable time, money, and energy in the ever-going court proceedings. Plaintiffs, complainants, defendants, accused parties, judges, lawyers, all die, but the cases in the Indian courts alone live for eternity. Do my words seem like an exaggeration? This is the plain, bitter truth. Not only do civil cases stretch for decades, even criminal cases do. A very typical example for judicial delay in India is the murder case involving Saravana Bhavan's founder. Driven by pure lust and greed, Saravana Bhavan's founder, late Mr. Rajagopalan, committed a pre-planned, cold-blooded murder in his early 50s in the year 2001. After almost 3 years after he committed the crime, he was sentenced with 10 years of imprisonment by a trial court in 2004. He got his sentence suspended while he appealed in the High Court, and he was out on bail. The victim's side also appealed. The case stretched further 5 years before the High Court, and in the year 2009, the sentence was increased to a life sentence by the Madras High Court. He appealed again before the Supreme Court. The appeal of the case stretched again for 10 years before the Honorable Supreme Court. Finally, in the year 2019, the Supreme Court upheld the Madras High Court's judgment, thus disposing of a case that was pending for 18 years. The Supreme Court graciously further gave him 3 months' time to surrender. His side further filed a petition and pleaded for an excuse to surrender in jail on medical grounds. The Apex Court denied and ordered immediate surrender. By the time he surrendered, he was bedridden and was directly taken to the prisoners' ward of Stanley Hospital. Almost a week later, he was permitted to be shifted to a private hospital. He died there 10 days later after surrendering before the prison authority. Except for the 1 year he was in prison as an under trial prisoner during the initial stages of the case, he managed to escape the jail term throughout his lifespan, as he was able to stretch the court proceedings for nearly 2 decades. After 18 years of delay, when the final judgment was confirmed by the Supreme Court, he was already bedridden due to his old age. He had successfully completed living his entire lifetime outside the prison by the delay in our criminal justice system. How can this final verdict be imposed on the convicted murderer? If he is dead, where is justice here? So in reality, as long as you're rich and powerful, the punishment for committing a cold-blooded, pre-planned murder driven by pure lust is just 10 days in jail. That too, you'll be serving only after you become bedridden due to your old age. In Rajagopalan's case, the wrongdoer at least served a few days as a convicted prisoner before his death. But in the case of former Chief Minister of Tamil Nadu, J. Jayalalitha, By the time the final Supreme Court's verdict came, she was already deceased. Where is the rule of law here? If we as a civil society take more than 10 years to dispose murder cases, how do we even remain a civil society? I read in my 8th standard civics book that consumer complaints must be disposed of within a period of 90 days. In reality, even consumer cases take up to 8 or 9 years. Leave consumer cases apart. Cases filed by women, that is wives against their husbands seeking maintenance for themselves and their children, take so many years in reality to get disposed. Whether a man has to pay his wife who is educated enough and who has the capacity to maintain herself is a different question. But for sure, the father has to contribute financially to the child. Even when a woman is educated, if she has no one in the family who is supportive to take care of the child, she can't go for a job in order to take care of the child. This makes a woman handicapped. Thus, a man who handicaps a woman in this manner by giving her a child and then deserting her has to maintain both the child and that woman. He cannot be a miser. It goes against the livelihood of the child and the women and violates Article 21 when these cases concerning livelihood of women and children stretch for many years. If the husband is absconding, it is almost practically impossible to get any child support from the husband, since the police will not take any serious steps to implement any non-bailable warrant issued by a family court unless bribed heavily. How will a woman who is contesting for a livelihood be able to heavily bribe the inspector in order to catch the absconding husband against whom a non-bailable warrant is pending? On the flip side of the coin, many women have taken marriage as a tool for money extortion. There is a great misuse of women-friendly laws to harass innocent men. So let's come to the point. In the year 2022, I personally appeared in a money recovery suit that was filed in the year 1995 in a Bangalore court. It was the same year I was born. The case didn't see an end even in the year 2022. This is no shocker when you compare it with what I'm going to tell you now. On January 16th, 2023, Business Today published an article regarding India's oldest pending civil case, which was filed in the year 1951. I quote, 1951, coming up for hearing before the Supreme Court in the month of 2023 and finally being disposed of since no advocate appeared in the court representing the case. Imagine that a case is filed by a person, that a person has become an MLA by committing fraud in the vote counting process. And if otherwise, that person who files this case would have won. A case like this in reality may stretch more than 5 years, which would exceed the total term of an MLA. So now, if the court gives a verdict that the accused person has committed fraud to become an MLA illegally, what is the use? The loss of the petitioner is irreversible, and the MLA who won by fraud would have enjoyed his entire term. To reduce the burden of the courts, and for quick disposal of disputes of various nature, tribunals and commissions were formed by various special acts. It takes decades for cases to be disposed before quasi-judicial forums as well. And these were created to provide quick justice. As an example, I have come across cases which were filed in 2012 before the IT Tribunal Chennai. These are cases between banks. These tribunals handle cases between banks and their customers who lost many lakhs of their life savings from their bank accounts for no fault of their own, and because of cyber theft and because of the alleged negligence from the bank side. The last time I spoke with the victim's family, the matter was pending even after 10 years had passed in a case before the said IT Tribunal Chennai. In one another case, the petitioner had died contesting the case for years, and the legal heirs didn't know how to continue the case since they didn't know the complete details of the case. And moreover, because of not having financial support to continue litigation, without unable to evaluate how many decades it would further take for the case to see an end before the IT Tribunal Chennai, the poor man who lost his lifetime saving because of cyber theft never saw the light of justice contesting the case for nearly a decade till his death. Most quasi-judicial forums were created to reduce the existing burden on the courts. Unfortunately, most quasi-judicial forums have presiding officers who aren't from the judicial background. Even members from the Indian civil services and state civil services who are currently serving or additionally given responsibility of being presiding officers of quasi-judicial forums. They are unable to allocate time to their duty as a presiding officer of quasi-judicial forums, apart from doing their job. I'm sorry to say this. Property laws are a joke in India. Litigation related to property disputes can even stretch for more than half a century. Land grabbers, trespassers, and vicious tenants make use of this situation to their favor, and it is highly unlikely that you will be able to remove them from your private property during your lifetime throughout court, unless you choose to settle with them outside the court or engage gundas on your own risk to evict them, or by bribing police who will act better than gundas if heavily bribed. When justice is extremely delayed in most of the cases, it goes against the concept of rule of law. We call it anarchy when there is no rule of law. Business can't thrive in anarchy. Corrupt politicians, corrupt government servants, and hardcore criminals are never punished for their wrongdoings. Even if they're arrested, they come out on bail soon and start doing more heinous crimes. You may ask, why do courts grant bail at all? In a democracy, bail is a right, and it should be. Because unless proven guilty beyond reasonable doubt after a fair trial, every accused is considered as an innocent. There is nothing wrong in it. It is a good sign of a civil society. The point is, how long will we take as a country to determine whether a person is guilty? In Saravana Bhavan's founder's case, the trial took only 3 years, which is comparatively quick. But the pending appeals before the High Court and the Supreme Court are the reason that caused the further 15 years delay. The High Courts and the Supreme Court set timelines for lower judiciary to dispose of cases. But who is going to set the timeline for the High Courts and Supreme Court? We can't blame them. Honorable lordships, judges, from the level of district municip to the Supreme Court, they are working like machines to deliver their best. It is the lack of optimum judges' strength to blame. If you have never been to an Indian court for any litigation, and if you have never witnessed the state of affairs personally, you may not have an understanding about how pathetic the situation is. I will share my personal experience in the last 4 years as a young practicing lawyer in India. Most of the Indian courts are so crowded that even lawyers don't have a bench or chair to sit. In most of the courts, more than half of the lawyers present in the court hall have to stand for hours together in a congested room without proper ventilation. For a single petty case, a lawyer has to stand along with his client the whole day waiting for their turn. If this is a situation for lawyers, the situation is more pathetic for litigants. They have to stand for hours together outside the court hall. They can only come inside when their case is called. Even if you're a pregnant woman or a senior citizen, you have to stand for hours together. Apart from the inside of the court halls being crowded, the entrance of the court halls would be even more crowded. There wouldn't be a way for anybody to enter the court hall. One has to fight his way inside the court hall when his case is called. I see more than 150 cases being heard in a day, roughly on an average, in most of the courts. Apart from doing their job for the court allocated to them, they also have to do in-charge duty for another court. I have personally witnessed a magistrate handling 3 courts at a time. I remember a magistrate in Pundamelli court literally running from one court to another court. I was about to make an emergency mentioning before the honorable magistrate, pleading him to pass an ex parte order for protecting a woman who was a victim of domestic violence. After the first round of calling was over in the court, as I was making an emergency mention about the emergency situation, the learned magistrate just stood and started running to the other court. He didn't even have time to listen to my emergency mention. I don't blame the learned magistrate. I would rather blame the system that puts him under extreme inhuman workload. Judges don't have the time to listen to even emergency mentionings during their extremely busy routines. Indian courts aren't like what Indian cinema projects them to be. Lawyers hardly get time to talk during their turn. There is no mic for judges in the lower judiciary. Judges cannot be expected to be loud to the entire courtroom, right? This defeats the concept of open court. Even lawyers, including myself, find it difficult to hear what judges in lower judiciary speak. Lip reading was also impossible when judges wore masks during the pandemic. Judges' jobs don't end in courts. They have to write judgments after going home. Indian judges are under so much mental stress. As on July 1st, 2023, the lady judge in the Judicial Magistrate Court number 1 was the in-charge judge for the Judicial Magistrate Court number 2, Chengalpet, as well as she was the in-charge judge for the Additional Mahila Court, Chengalpet. And also, she was said to be the in-charge judge for another court. I'm not sure about it, but she was also said to be an in-charge judge for a court in Maduranthagam Taluk. So almost 3 courts a learned magistrate is taking care at a stretch. Is she a human being or a justice delivering humanoid robot? Imagine what kind of impact this level of work pressure can have on the quality of service of the judicial offices. Keeping judges under this level of mental stress is dangerous. They decide the life and liberty of people. An article from Times of India says, some Indian judges do write judgments that they themselves cannot understand. The stress and workload may be a reason for this. Workload of judges affects the quality of justice delivered. There is a lack of transparency or clarity in the listing of cases in courts. Even after being mentioned before the Chief Justice in open court and even after receiving a slip to the registry, many cases are kept without being listed for a long time. Many legal professionals and litigants are of the opinion that listing of cases in various high courts and the Supreme Court isn't being transparent and simple. There are cases in high courts and Supreme Court pending and not being listed for years together. Any country that becomes a new democracy needs a good constitution that should uphold democracy and clearly state the powers, rights, duties and responsibilities of all. And that constitution must have provisions that give ultimate authority to the judiciary to protect and uphold the constitution at any cost. Our constitution is not just good, but one of the best constitutions ever written in the known history of planet Earth, which really has all components ensuring democracy and people's liberty. Our forefathers have written the constitution in such a way that nobody is ultimate, not the president, not the prime minister, nor the chief justice. It is the law that is supreme in India. The checks and balances in our constitutional design ensure rule of law. Indian constitution is the supreme rule book that guarantees us fundamental rights, duties, prescribes principles according to which a government must act. If our great constitution is exercised to its letter and spirit, we must be the best civil society in the world. The ultimate guardian of our constitution is our judiciary. For such a great constitution, which is very much dependent on the judiciary for its protection and proper application, the judicial system must be so strong. The only weapon for the citizens to fight against corrupt politicians, government officials and wrongdoers is our Indian constitution, which can be exercised to the benefit of common men only by our judiciary. If the judicial system, which is the guardian of our Indian constitution, rule of law and people's right is strong enough, the issue of corruption can be effectively addressed through courts of law. But the guardian of the constitution is purposely kept weak. This is the situation of the Indian judiciary today. Approximately, there are only 18 sanctioned judge posts per 10 lakh people in India. In developed nations, there are around 50 plus sanctioned judge strength for every 10 lakh people. India cannot always consider itself a developing nation. Now we are one of the very few countries that have sent probes to Mars. We have the fastest cruise missile, BrahMos, which is compatible with nuclear weapons and is almost impossible to intercept once loaded and fired, even by the United States, which claims itself as a world superpower. India's handling of the COVID-19 pandemic was better than many other countries which claim themselves as world superpowers. Still, should India consider it a developing nation? Shouldn't we have a judges ratio on par with that of the developed nations? What is the use if we become technologically advanced But if we remain so backward in the justice system, we already have an extremely less number of sanctioned judge posts to match the Indian population. Even with that very less number of sanctioned judge posts, if there is almost 25% vacancy most of the time, what would be the state of justice in my motherland? Here are the shocking figures regarding the unfilled vacant judge posts in India. Currently, Wikipedia shows an estimated population of India as 1.4 billion. As of December 2022, there are 25,773 total sanctioned judge posts in our country. This includes 24,631 judges in all the subordinate courts, 1,108 judges in the high courts, and 34 judges in the Supreme Court. As of December 2022, there were approximately 5,343 vacant judge posts in the subordinate courts, 330 vacancies in the high courts, and 6 vacancies in the Supreme Court. A total of 5,840 unfilled judge posts in the entire Indian judiciary amounts to almost 23% of the total sanctioned strength. A quarter of total judiciary strength always remains unfilled. I came across an article that says nearly 3.1 crore cases are pending before the lower courts. 46 lakh cases are pending before all the high courts of India. In that 46 lakh cases, at least 8 lakh cases are pending for more than 10 years. And at least another 8 lakh cases are pending for more than 5 years. Honorable former Chief Justice of India, T.S. Thakur, shed tears on the open stage in a conference of Chief Justices and Chief Ministers that took place in the year 2016 while delivering a historic speech. The tears he shed are a manifestation of morality and justice. I salute and bow down before Honorable Lordship T.S. Thakur for his great speech and for his spirit to uphold righteousness in my motherland. He said that you can't shift the entire burden on the judiciary. He said the Law Commission report in 1987 gave recommendations to immediately increase the sanction strength of judges at least to the ratio of 50 judges per 10 lakh people from 13 per 10 lakh people that existed then. He said nothing had changed in all the years from then. He lamented that the central government said the state government should take responsibility, and the state government said the central government should take responsibility. And in this tug of war, nothing has improved over the years in the judiciary. His concern was that the population has seen a drastic increase since the report, and that 36 years had passed and nothing had changed. This was his concern. Expecting the politicians to increase the number of judges or the fundings on judiciary is like expecting the thieves to send themselves to jail. If they do so, the single largest class of people who are going to be affected are the politicians. So only the people must get into the task of increasing the judges, courts, and the judicial fundings and protecting their constitution that solely belongs to them. But how? In democracy, people can't do this directly, but do everything by their representatives only. 50 judges per 10 lakh people is just a minimum benchmark set by the United Nations organization for India to really be a good democracy and a good civil society. It requires at least 150 judges per million population, which is the exact strength of judges on par with the United States. Even China, which is an authoritarian state, has 300 judges per million population. The CPC and CRPC, which is the Manual for Civil and Criminal Law, have their origin from British India. They have to be amended and updated to the growing needs. Orders and daily adjudications never get uploaded on e-courts on time. The strength of the judicial support staff too are very less, and they are also under same pressure. Getting certified copies may take months. Malfunction in photocopying machines is often said as an excuse for delay in getting certified copies. E-court's website crashes most often. Getting phone signal within most court premises is a challenge. To make the open court system a reality, all court proceedings, except few sensitive proceedings, must be recorded and telecasted. This will ensure transparency and people can see the pathetic state of affairs in our judicial system. There is a complete absence of fair criticisms on the judiciary from the members of the advocate fraternity. All practicing lawyers who love this noble profession must not fail in their duty to voice their criticisms against the flaws in the judiciary without fearing the consequences. Judges must not be criticized in their personal capacity, or baseless allegations shall not be made against any honorable judge. But every legal, illogical observations made or judgments passed which are against the principles of natural justice and the precedents and the judgments and observations which are unconstitutional must be openly debated and fairly and boldly criticized by the legal fraternity. The bar and the bench are parallel as observed by the Supreme Court. The legal fraternity doesn't give its tough fight to keep the above observation a reality. The next big hurdle for India being a welfare state is the poorest policing. Indian policing has colonial legacy. They were made to oppress people and to serve their colonial masters and not to serve the people. India's police force is considered to be among the weakest, apart from having a very less strength to match the people ratio. State police departments also have more than 23% vacancy against its sanctioned strength most of the time. They have to work more than 12 hours a day and are never given a proper weekly leave. The corrupt police force in India is kept like aggressive hound dogs, I'm sorry to say, to serve the corrupt politicians. All that they need to do is mindlessly obey the orders of the politicians. And the political leaders will never make attempts to discipline and reform the police force, since if reformed, the police force may no longer be under their undue influence. The police force must be as majestic as a lion, but the ruling politicians are keeping the police force as their tamed hound dogs, which would hunt on their command. As a treat, politicians allow the police officials to loot as much as they can, acting like kings within their jurisdiction. A High Court judge, Honorable High Court judge, made an observation that more than 80% of the police personnel in Tamil Nadu were corrupt. I really wonder, why 20% wasn't included in his observation. People study to become police officials in India merely for the power it gives, not all, but many, to do extortion in broad daylight. Most of the state police hesitate so much to register FIR, even in genuine cases, merely because a new case increases their workload. This violates the Supreme Court guidelines. The only thing that motivates the police is currency. This is the plain bitter truth. The police force in India is so rotten. It is scary that murderers, gundas, thugs and psychopaths are wearing khaki and are being cops in India. They hardly lose their jobs or go behind bars for the crimes and human rights violations they commit. I'm not here to say all Indian lawyers are so honest and ethical. It is highly unfortunate that many good lawyers themselves have lost hope on our system and have started to use this profession as a money-making tool, exploiting the clients. I'm not denying that very fact. Indian state police departments are outdated in handling cybercrimes. Many lakh crores of money are looted in India by cyber criminals, scammers. Many people kill themselves because of the menace of cyber criminals. Unless someone dies, cyber criminals aren't chased by police. Judicial reforms must happen hand to hand with reforms in the police force. This is what requires India to become a democratic civil society. Democracy means participation of the people in governance, and participation means raising questions. The RTI Act 2005 empowers people to question any department of the government, with few exceptions. RTI was intended to be a great tool to enable people to have access to public information, which enables transparency. It mentions powers of the Information Commission to impose fine against concerned government officials for not providing required information. What is the use? In India, all laws are great on paper, but never serve the purpose practically. As of October 2022, more than 3 lakh cases are pending before the various state information commissions. According to a separate report by the Transparency International, 1/4 information commissioner posts are vacant and there are only 5%, that is only 8 women information commissioners in the country, out of a total 165 posts of information commissioners. 42 are vacant, including 2 chief state information commissioners. 2 of the state information commissions in Jharkhand and Tripura have been completely defunct for 29 months and 15 months respectively. Quoting from a news article from The Hindu, an analysis of penalties imposed shows that the commissions did not impose penalties, the information commissions did not impose penalties in 95% of the cases where penalties were potentially impossible. No appointments being made in an information commission for 29 months and 15 months in another case for a position that is so vital to keep India democratic is a criminal negligence by the people in the responsibility to take action for appointing them. A great human being, Mr. Jayaraman, the founder of Arapur Foundation, which is known for its RTA activism, has expressed his dissatisfaction in an interview over the conduct of the Tamil Nadu Information Commission, which is denied to grant information about the details and the statistics of the cases it has disposed, the pendency of cases, and regarding the penalties imposed. If a state information commission itself fails to provide information under the RTI Act, what will be the quality in the cases it adjudicates? Information Commission, though not a court, is a quasi-judicial forum and is almost like a court and needs to be actively functional. Increasing the strength of the information commissioners across state information commissions and central information commission is also vital. India spends just 0.8, less than 1% of its expenditure on judiciary. This is a reason for rule of law, democracy and justice being a mirage in India. This is the reason why money power and muscle power are overpowering rule of law and democracy in India. RTA Act is India's greatest step towards becoming more democratic. The government officials are being fearless and the Information Commission is also being friendly towards the government officials, as seen from the facts above. The RTA Act must be amended in order to make it more scary to the government officials who slit the throat of democracy by denying information to the citizens, making transparency in governance impossible. Mere fine amounting to a few thousand rupees is not scary enough to the officials. The Act must be amended to bring dismissal from service, along with a few years of imprisonment as a punishment for denying rightful information, stating some illogical reasons. My very humble proposal as a young practicing lawyer to the great parliamentarians of India, to make India a land of justice and righteousness. These are my humble suggestions. Number 1, the Indian government must declare a 5-year plan titled as the Great Reformation of the Indian Judiciary in the Parliament. Number 2, an yearly budget allocation of at least 15% as against 0.9% towards the judiciary. Number 3, formation of a committee consisting of practicing lawyers from all categories and levels to propose amendments to various barracks and even the constitution in order to eliminate practical difficulties and quick disposal of cases and to make courts people friendly. The Indian parliamentarians, number 4, must conduct and conclude the great debate of whether the collegium system is needed for a democratic civil society. Number 5, the state governments must take steps to triple the sanction strength of the subordinate judiciary, thus increasing the sanction strength of judges and support staffs by 3 times the current strength. Number 6, similarly, the central government must take steps to triple the sanctioned strength in the high courts and the Supreme Court. And to impose point number 5 and 6, I said, it is really a cumbersome procedure. Constitutional amendments must be made to simplify the procedures that I mentioned in 5 and 6. Number 8, increasing the strength of the presiding officers and support staffs across various quasi-judicial forums. Number 9, serving civil servants must not be made presiding officers, since they cannot perform judicial duties in middle of their already burdening work. Number 10, the 5-year plan must focus on digitalization and modernization of the judicial infrastructure. Number 11, fair criticisms on wrong, illegal, illogical, unconstitutional judgments passed by courts of any hierarchy must be encouraged to uphold rule of law in judiciary and to hold judges accountable to people without the fear of contempt of court. Since fair criticisms on judgments do not amount to contempt of court. Number 12, open more subordinate courts in the district levels. Number 13, open branches of high courts within states. Number 14, open more branches of the Supreme Court, at least 3 more, in order to make Supreme Court accessible across 4 directions of India. Number 15, video record all judicial proceedings and mandate all judicial support staffs to wear a body camera throughout the day to eradicate corruption among the judicial support staff. I know this looks like an utopian dream. All physical reality today was once only a thought. Most intensive thoughts have powers to manifest themselves into reality. Fortunately, we don't live in North Korea. We are a blessed democracy with one of the constitutions that is best in the world. Our freedom our ancestors got from the British, sacrificing millions of their lives, doesn't make sense if we let our country rot in corruption and anarchy. There are 2 choices. People can keep protesting for each and every basic necessity, or protest for one single cause of strengthening the judiciary, which will prevent the need for them to protest for anything again, as everything will become lawful with a strong judiciary. Once our judiciary is reformed, as I said above, people need not go to the streets to protest, but instead choose to go to the courts to punish or sue the politicians and the government officials for the damages or for their defaults, and get directions to the government officials and agencies acting unlawfully or failing their duties, as judgments would be pronounced quickly and efficiently if the judicial budget is increased, if the sanction strength is increased. People need not adjust to every injustice as they adjust today. Once this is achieved, there is no awareness regarding this truth among the people. Awareness regarding this must spread, and a historic people's movement like the one that happened during Indian independence must happen. Only then the political parties will come with this proposal in their manifestos for judicial reforms, and one fine day this Herculean task will be achieved. I know no utopia would be born that day, but a society which is many times far better in terms of morality and justice would be born. Reforming the Indian judiciary from top to bottom is absolutely the need of the hour. There are legends within the system who have been fighting for remedies within this remediless system without giving up, keeping their frustrations on the system apart. I'm just a dust in the legal fraternity. I would think of myself as an infant who is learning to crawl when it comes to my contribution towards this great noble profession. I'm still finding my footing as a lawyer. Some has to reveal these facts to every Indian. I have taken that responsibility. Jai Hind.